Hi everyone, I'm Muhammad Fidaus Farhan bin Suhaimi. Today, I want to talk to you about wills versus trust under Malaysian law. We're going to dive into the comparative analysis to see exactly how these two legal instruments stack up against each other. To kick things off, let's really unpack how the law defines these two tools. Section 2 of the Wills Act 1959 doesn't just say a will is a document. It describes it as a formal legal declaration of exactly what a testator wants to happen to their property, or even who gets the custody of their own children after they pass away. It covers everything from testament to codicils and many other things. On the flip side, the Section 3 of the Trustee Act 1949 describes a trust quite broadly. It's not just your standard express trust. It extends to implied and constructive trust, situations where the trustee themselves has a beneficial interest, and even duties related to being a personal representative. Now, here's an interesting twist in Malaysia due to our dual legal system. Section 2, subsection 2 of the Wills Act clearly states that the Act doesn't apply to the wills of Muslims. But for trust, it is a completely different story. Scholar Yusnita Muhammad Yusof and Akmal Hidayah Halim point out that because our trust law comes straight from English common law, it applies to everyone across the board. So, let's say if a Muslim sets up a civil express trust, the trustee is still strictly bound by the Civil Trustee Act 1949. Alright, let's zoom in on wills first. What does it take to be a capable testator? The law looks for two main things. First one, testamentary capacity. And the second one, testamentary intention. For capacity, the first obvious hurdle is age. Section 4 of the Wills Act make it crystal clear. You cannot make a valid will if you are a minor. And under Section 2 of the Age of Majority in 1971, that means that you have to be at least 18 years old and above. The second one, it is much trickier. The requirement is having a sound mind. Section 3 of the Wills Act says anyone of sound mind can dispose of their property. But how do we prove something that we cannot see, right? For over a century, courts have relied on an old 870 cases called Banks and versus Goodfellow. It asks, does the person understand what a will is? Do they know what property they own? Do they know who they should be providing for? And are they free from any delusion affecting those decisions? This four limbs test has been used by several cases across Malaysian border. The Malaysian Court of Appeal added a fascinating layer to this in Toyo Pei and Chua Kui Hien. To give you some context, the facts of this case are quite tragic. The testator was suffering from nose cancer and taking heavy medication for severe headaches. He had separated from his wife, moved in with his family, and actually filed for divorce. He then executed a will, leaving his wife just one single ringgit, while giving his share of their matrimonial home to his mother and children. Naturally, his wife challenged the will validity, arguing that he lacked capacity while doing that will. But the court held that you actually only need a very slight level of testamentary capacity for a will to be valid. To strike it down, there has to be a significant, insane delusion present right when the will is made. They also made a strict point to separate suspicious circumstances surrounding the will's creation from the actual mental capacity of the person making it. But here is the main problem. Assessing the human mind isn't straightforward, something that you cannot look at. So Sergio Pereja points out a massive gap here. Doctors see cognitive decline as a slow, gradual spectrum, but the law demands a straight yes or no. For disease like dementia, this is tough because courts struggle to figure out exactly when that twilight of cognitive decline turns into a total darkness. We see this strictness in Costi and Chaplin, whereas a man delusion about a global conspiracy completely invalidated his will. However, the law isn't totally rigid. Take the lucid interval rule from Re Anguilla. It shows that having a history of mental illness doesn't automatically void a will. If you sign it during a temporary moment of clarity, it is valid. And on the flip side, as seen in Airy and Hill, Actually, even a temporary impairment, like being heavily under the influence of drug or alcohol at the times of the signing, can actually get a will thrown out and become void and invalid. This brings us to some major criticism of that 1870 Banks case. Dr. Kenneth Schulman and his colleagues argue it is high time for us to update this for the 21st century. You see, the old test was built for dramatic psychiatric illness with clear delusion. But today, in this modern day, most court battles are about dementia, which slowly and quietly erodes memory and judgment. Plus, things about modern wealth. In 1870, estates were pretty simple. 5 cows, 10 goats. But today we are dealing with offshore account, corporate shares, and blended families. Understanding all that takes a lot more brain power than the old tests account for. On top of that, using outdated terms like unsound mind or imbecility is stigmatizing and medically useless today. We really need a legal test that speaks the same language as modern diagnostic tools like right now. For example, DSM-5. Now, let's shift our gears and talk about trust. What makes someone a capable settler? Just like wills, you need to be of age and have mental capacity. For minors, it depends entirely on what kind of property that they are trying to put into a trust. So let's break down the actual statutes. First, Section 43 subsection A of the National Land Code expressly states that minors cannot legally own land because they don't have ownership. Any trust of immovable property or land they attempt to create is completely void from the start. Second, Section 4 of the Wills Act 1959, like I already mentioned before, explicitly states that no will made by any person under the age of majority shall be valid. Therefore, they absolutely cannot set up a testamentary through a void. It will be completely void. However, there's a small exception though. They can create a lifetime trust for movable property, though these are voidable, meaning they choose to cancel them during their minority or within the reasonable time after reaching their adulthood. When we look at the mental capacity needed for trust, specifically without a court committee involved, we look at the R.E. Binney case. Legal expert Emma McCall explained that court actually bypassed modern statute for this and rely purely on the R.E. Binney common law sliding scale. In that case, a mother with advanced senile dementia gave her only real asset, her house, to just one of her daughter who was her caregiver. The other kids sued to void the transfer, and the court ruled that the level of brain power you need depends entirely on the size of the gift. If it's a small gift, you don't need to have much understanding. But giving away your biggest asset, that requires a massive level of understanding, equal to making a will. The donor has to comprehend the size of their property and the claims of the heirs they are cutting out. However, things change completely if a court committee is appointed. Under Part 10 of the Malaysian Health Act 2001, once that happens, the person loses all legal power to manage their property. So, meaning any trust they try to make is instantly void. The only exception is if they manage to declare the trust during a lucid interval before the committee was appointed, as seen in the R.A. Anguilla. So the question that we've been waiting for, looking at both sides, is this huge difference in requiring capacity between a will and a lifetime trust actually justified? A lot of experts say yes. Dr. Juliet Brooke thinks the R.E. Binney sliding scale is brilliant because it perfectly balances personal freedom with necessary protection. Kimberly A. Whaley puts it bluntly, you cannot impoverish a dead person. I really love that one. A will only takes effect when you are gone, but if you give away your main asset while you're still alive, you are instantly financially vulnerable. That's why the law sets a higher bar here, to protect the living from ruining themselves or being exploited. And Malaysian scholar Rusna Dewi Abdul Rashid agrees also, emphasizing that the sheer risk of instant destitution is exactly why the court demands maximum strictness for lifetime transfer. So here's my take on it. I completely agree that the strict rule for lifetime trust under REBNI makes perfect sense today. It is a necessary shield against elder abuse because the risk of financial ruin is immediate. However, while we do a great job protecting the living, our rules for wills are stuck in the past. Because I feel like the 1870 Banks case just doesn't account for modern medical realities like early stage dementia. So someone could easily pass that test but still lack the essential executive function to protect themselves from greedy relative. So moving forward, I feel like we need to make a big changes. First, our statutes need to be updated to legally assess the executive brain function using modern framework like the DSM-5. Second, we should stop using these fragmented document-specific rules. Instead, jurisdiction should use one single functional assessment that evaluates whether the individual can truly understand and weigh the consequences of the exact decision at hand. To wrap things up, our trust laws offer great protection for the living, but our testamentary laws desperately need an update to protect the people in the 21st century. So, with all been said, thank you so much for listening. Hope you're having a good day.